By now you've all heard about Hunter Biden getting off with a slap on the wrist over tax evasion and falsifying gun records, possession of a gun while being on narcotics. Well, this is what I've got for you today. So we're going to get into this. Hunter Biden mystery. Why did Delaware prosecutor not bring charges his office approved? This is something we're going to get down to. We've been talking about it for months now, and it's actually been going on for years. Since 2014, they had stuff on Hunter Biden that they could have brought felony charges up. So here we go. An IRS document from early 2022 states Delaware U.S. Attorney David Weiss signed off on bringing a felony tax evasion case against Hunter Biden that stretched back to 2014 and money from Ukraine, creating fresh intrigue as to how the president's son ultimately escaped more serious charges and got a plea deal on tax misdemeanors involving conduct years later. This document, a prosecution conclusion and recommendations memo, escaped much noticed when it was released last month by the House Ways and Means Committee, along with the testimony of IRS whistleblower Gary Shapley. And I did a video on that a few videos back. But it's taken on new significance now that Weiss has issued carefully crafted statements to Congress appearing to contradict Shapley and second whistleblower's account for what went in the case. Shapley and publicly unnamed colleague were the top two IRS agents on the Hunter Biden tax case. They told Congress in a transcribed interview that Weiss's office wanted to bring a felony tax case against Hunter Biden, charging him for crimes dating 2014, but was turned down by his Joe Biden-appointed colleagues in Washington and Los Angeles, where the alleged crimes occurred. So much for no interference from Merrick Garland and the DOJ, huh? Weiss was appointed by former President Donald Trump and was kept on by the Biden administration to continue overseeing the Hunter Biden. The whistleblower alleged Weiss told the investigative team he requested to be named a special counsel so he could bring charges himself, but was turned down by the Biden Justice Department. And then Weiss's office let the statute of limitation expire on crimes before 2017, a claim that directly contradicts Attorney General Merrick Garland's testimony. There were no political roadblocks to prosecuting Hunter Biden. This administration is full of nothing but lies. To get this cost, and there should be a stiffer penalty for lying to Congress in a sworn testimony. You are under oath when you go to these hearings. It should be treated just the same. They should be put in jail as soon as you find out they were lying. Weiss had issued multiple letters to Congress since Shapley's testimony was made public, saying he couldn't talk much about the deliberation because Hunter Biden has not yet appeared in court to consummate his plea deal, which I hope it does not go. It's looking like they're going to postpone this plea deal. But the chief federal prosecutor from Delaware acknowledges his ability to file criminal charges geographically limited from bringing charges in the two other cities and would have first consulted his colleagues in those districts. He also was flatly denied he ever requested or denied special counsel status, while suggesting he could have requested special attorney status to bring the charges in the district outside Delaware. Of course, they're going to lie and turn everything around on him. I have followed the process outlined in my June letter and have never been denied the authority to bring charges in any jurisdiction. Wise wrote in a letter this week to Senator Lindsey Graham, the top Republican on the Senate Judiciary Committee. So now he's lying again. Wise, his current account to Congress is essentially that he had the authority to bring the charges, which is begging the question across Washington as why he did not charge Hunter Biden for these felonies dating to 2014. That's Shapley and the other agent described in their testimony. The question is taking on more significance in the IRS memo completed on January 27, 2022 that flatly states both a prosecutor in the DOJ tax division named Mark Daly and Weiss, top deputy in this case, Assistant U.S. Attorney Leslie Wolf, reviewed the memo, and that Wolf herself signed off on the charges of charging Hunter Biden for felony tax charges, alleging he did not pay taxes all the way back to 2014, including $400,000 he got from Ukraine. Controversial Burisma Holdings Energy Company. The recommendation for prosecution is based on the facts above and recommendations Robert Hunter Biden to be prosecuted under the provision of Title 26 U.S.C. Section 7201 and 7206 for the tax year 2014, 18, 19, and under the provision of Title 26 U.S.C. Section 7203 for the tax years 2015, 16, 17, 18, and 19. The IRS memo signed by the case agent and approved by Shapley stated. A draft of the SAR was given to the DOJ tax senior attorney Mark Daly, as well as Assistant Attorney Leslie Wolf. The memos also stated that Wolf has reviewed the appendices and the charges cited in this report and agrees with the prosecution recommendation of the above cited charges against Biden. Congressional investigators and one Shapley lawyer told Just the News they are confused about why Wise is claiming he had the authority to bring whatever case he wanted, then didn't bring him up, didn't charge him. Leslie Wolf concurred with the recommendation memo from the agents in 2014 years ago should be charged, and they should be charged as felony. In Power Oversight whistleblower, Senator found Jason Foster, one of Shapley's lawyers, told the John Solomon Report podcast, she is Wise's agent in those discussions. She is the primary person at the ground level. She is the person who Gary Shapley would have had the most interaction with, most frequently on the prosecution team. She wouldn't have agreed and put in and allowed them to put it in writing if she didn't have Wise's agreement, Foster also said. So then the question becomes for Wise, why on earth, if he had authority to bring charges, this magic golden ticket that was never written down, apparently by Merrick Garland, that he could bring charges wherever he wanted, whatever he wanted, then why didn't he do so? That should be a question on everybody's mind, because there's people out there that has done less than this and has went to prison, except for this cokehead, that he shows it right on film, doing illegal drugs while driving, having a gun, falsifying gun paperwork to get a gun, and what's he do? He gets misdemeanor charges on him. Senator Chuck Grassley, Republican from Iowa, he added a second line of inquiry about Weiss, revealing this week that Weiss's office, in the person of Wolf, was briefed 2 weeks before 2020 presidential election that the FBI had an informant alleging Joe Biden was involved in a bribery scheme involving Ukraine and Burisma. The briefing occurred in October of 2020, and they hid that. The revelation begs the question that I've been asking since the start of my oversight in this matter, Grassley stated. What steps have the Justice Department and the FBI taken to investigate the allegations? Grassley wrote Weiss on Sunday. You, Attorney Merrick Garland, and Director Wray have failed to answer. Some of these questions I'll put out there real quick for you. When did you become aware of the October 2020 briefing provided by the Justice Department, the FBI officials, and Wolf in the FBI Baltimore office? Are you aware of any steps the Wolf in the Baltimore office took to investigate the information with the FD 1023 before and after October 2020 briefing? If so, what steps have you taken and when? If not, why not? Why were the IRS agents not included in the October 2020 briefing? These are all questions that Grassley wrote to DOJ and the FBI. Does your scope of your alleged ongoing investigation include criminal bribery with respect to the alleged criminal scheme between a foreign national and then Vice President Biden and Hunter Biden? If not, why not? Have you taken any steps to recover the alleged audio recording or related evidence referenced in the 1023? If not, why not? One more. When were you assured that you would be granted 515 authority in the District of Columbia, the Central District of California, or any other district where charges could be brought in the Hunter Biden matter? Have you requested the specific authority yet? If not, why not? If so, when, where, and was the request satisfied? Now, these are questions that they're asking them, and this is another thing that they know the answer. Then they just have to, take steps to get to that point. But I wish their steps would go a little fast. Ray needs fired and brought up on charges for perjury, along with Merrick Garland for treason. And this is stuff. These are questions that everybody's wanting to know of why this garbage Hunter Biden, and we know why the answer is, getting off on all these charges just with a slap on the wrist. We know why, because of Daddy. Daddy is as corrupt as it comes, taking money from China, Romania, Ukraine, Russia. He's as dirty as it comes. They have the proof. They need to do it now. They need to charge it. This is treason. Doesn't fall under the Presidential Protection Act. And all these idiots, liberals, want to bring up that Trump has done this, Trump has done that. Trump has never been prosecuted and found guilty on any of this stuff. So you shut your mouth until he is. So let me know what you guys think about this Hunter Biden bullshit. And leave any questions, comments you have below. And if I get any more information on this or any other subject, I'll get it out. Until then, this has been The Talking Point with the Country Conservative. I'm Charlie, and I'll see you next time.